Thank you. I'm Jack Turner. I've been invited to give this lecture by Young-Hoon Chun for course 2.96 and 2.961. I'm going to be talking with you about inventions, patents, and MIT's policy in the development of patents and their licensing. I'm Jack Turner. I'm the Senior Associate Director of the Technology Licensing Office. My career spanned, beginning after an undergraduate degree at MIT in electrical engineering, work with Raytheon for 10 years, and then two startup companies, both in the Boston area, one in industrial electronics, instrumentation, and the other in consumer electronics. Then in 1993, I joined the Technology Licensing Office at MIT. So we're going to begin by talking about patents. Following that, we'll talk about MIT's policy and its licensing philosophy. Then we'll move on to the elements of a license agreement and the typical terms in a license agreement. This, of course, is a license agreement from MIT to a company. Following that, I have some samples of license agreements and talk a little bit about the valuation of technology as we license it from MIT. And then we'll move on to the actual statistics of the Technology Licensing Office at MIT for the fiscal year 2017. So to begin, what is a patent? A patent is a grant from the government. It doesn't have to be the U.S. government, but for a U.S. patent, of course, it does need to be the U.S. government. And the government gives you a grant that allows you to exclude others from making, using, selling, offering to sell, or importing an invention that is described in your patent. And this exclusionary period is for 20 years. It begins with the application date of the patent and lasts for 20 years from then. There was a change in U.S. patent law in 1995. Prior to that, patents lived for 17 years beginning from their issuance date. The various types of patents, the ones that we here at MIT are most familiar with are called utility patents. Utility patents cover machines, which could be robots, motors, or circuits, processes, in other words, the method for making something, method of manufacturing being an example of a process patent, articles of manufacture, things that come out of the manufacturing process rather than the way you make them, such as a frying pan or a hair comb or something that ends up being made. Composition of matter is another type of patent, and this would be chemical compounds, for example. Design patents is another type of patent. A design covers the ornamental design of something, just as its appearance. And we have a few design patents here at MIT, but not very many. And plant patent is the other type of patent, and this would be a patent covering a new variety or a distinct variety of a plant. And that is not common here at MIT. So what's required to get a patent? In order for the U.S. Patent Office to grant you a patent, the patent must be novel, it must be useful, and it must not be obvious. So the invention, which is described in the patent application, must be novel, useful, and not obvious. So what does novelty mean? Novelty means that it must be something that has not been described before in another patent application, or in fact not described in any publication. If you do make public disclosure of your invention, in the United States you have a year to get a patent application on file. After that 1 year, the opportunity to patent something is extinguished. An oral disclosure does count in the United States, but slides, posters, placards, and website presentations are disclosures and do start this 1 year clock running in the United States for novelty. For the rest of the world, absolute novelty is required, and you must file a patent application before any public disclosure of the invention. Because this is true in the rest of the world, we try to file our U.S. patents prior to any disclosure so that we don't run afoul of the absolute novelty requirements in the rest of the world. note that once you have a U.S. patent on file, it is okay to make a public disclosure because your patent application, though not published, is pending, and the rest of the world will give you a year after the filing of your U.S. patent to get a patent on file in other countries. This is true in 193 other countries. But the U.S., that's the date from the beginning of the U.S. filing. That grew out of the so-called Paris Convention in 1893. Usefulness is the other requirement for getting a patent from the U.S. Patent Office or any, and this is usually not very difficult to establish or convince the Patent Office of. The most difficult is the requirement that the invention that you're disclosing and trying to patent is not obvious. And obviousness is a subjective determination, and it's often very difficult. It's what we spend most of the time and difficulty in convincing the U.S. Patent Office that the invention we're trying to patent is not obvious. Typical questions that would be asked of yourself and of the Patent Office is, would somebody who's skilled in the field of the invention but who's not seen the invention or disclosure think that what you have done is obvious? And another way to think about this is what you've created just a matter of engineering, or is there an element of inventiveness or creativity that distinguishes your invention from other things? The factors that are considered in making this determination are, has there been elaborate or big major commercial success that can be attributed to the inventive feature? Does it fulfill something that has been described in literature or in business publications that is something that's been needed but not available for a long time? And if it accomplishes something that others have said could not be done or would not work, would be big factors in determining not obviousness. The patenting process begins once the patent is allowed. A patent is issued, usually 3 to 5 years after the application was filed. The duration of the patent, as I mentioned before, begins from the date of the patent application and lasts for 20 years. And it's important to know that there is no patent protection until the patent actually issues. So even though you've filed a patent application and you may see products that are marked with patent pending, there is in fact no patent until the patent actually is issued by the U.S. Patent Office. It's possible to file what's called a provisional patent application. This is an inexpensive application which can be filed, and if you're a small entity, which MIT and other universities qualify as, the filing fee is only $130. And it does not require that you file this application with any claims at the patent, so that it's not entirely clear what the invention is without the claims. It does, however, establish a priority date, and this is important for establishing the date on which the first patent application claiming or describing this invention was filed. The material included in a provisional patent application doesn't see the light of day at all until or unless there is a subsequent patent filing of a utility or a real full utility or utility patent application. But material that comes into the public domain or is published by someone else between the time of the provisional patent filing and the filing of the utility application, it cannot be held or will not be held against the patent applicant as prior art, because the priority date of the provisional application stands before the publication of that other material. The Patent Office doesn't take any action on a provisional patent application. It is not published until or unless it is used as the basis for a utility patent application. So important points to think about in the patent process and what a patent actually gives you. An issued patent permits the owner to stop somebody else, to prohibit someone else from using the invention. It does not, in fact, allow the patent owner to do anything other than prohibit others from doing what's described in the patent application. This is very, very important to understand when you think about what a patent actually allows the patent owner to do. Because any invention that you have might, in fact, infringe the claims of somebody else's patent. Even though you have claims that were allowed in order for your patent to issue, there might be another patent that you could infringe with your product that was issued before and even to another person that would be infringed by your use of what you have described in your patent application. So what does it mean to prohibit others? If you think somebody is infringing a patent that you have or doing one of the things that you are allowed to prohibit, you can notify the suspected infringer. You can send a letter to that infringer saying, please don't practice my invention anymore. That's often referred to as a cease and desist letter. You can offer a license to the person or company that is practicing your invention. And this license would be permission for them to practice the patented invention in exchange for some consideration, perhaps a royalty, perhaps a one-time payment, or other consideration. This failing, if you are unable to get the suspected infringer to stop infringing your patent or take a license from you so that they can practice the patent, you can file a patent infringement lawsuit in federal court. This, however, is very expensive and it will take a long time to reach conclusion. We think in terms of millions of dollars to get all the way through a patent infringement suit, and at least 3 to 5 years, and it's often much longer depending on how reluctant the infringer is to agree to license or stop practicing the patent. There's little chance that you will actually be able to recover from the infringer any of the costs you've incurred in order to pursue this infringement. So it's very important to understand the business rationale before entering into a patent infringement operation. You are likely to be able to get a royalty payment for both past and future product sales from the infringer, and you can force the infringer to not sell any more products that infringe the claims of your patent. So a patent example that I use to explain this, how the patent allows you to prohibit somebody else from practicing a patent follows here. Let's think about a stool, and imagine that no one had invented a stool before this particular patent application. So you have a stool, and the couple of claims that a stool might have might be described as a piece of furniture to be used by a person to sit on. And in addition to that, it has a horizontal platform supported by 3 or more vertically disposed rods, let's call them legs, that fix the platform at a fixed height between 12 and 30 inches above a horizontal surface that's above the floor. So that's the patent on the stool. And someone else comes along and they are fully aware of the stool patent, but they say, gee, I think I can improve upon the stool, and I'm going to invent something, or I've invented something which I'm going to call a chair. And here are the claims of the chair patent. The first element of the claim is the same as the first element of the stool, a piece of furniture that somebody's going to sit on. The second element of the chair claim is that it has the horizontal platform, just like the stool. But this inventor has added something to the chair patent. That is a vertical element that's attached to one side of the horizontal platform that the seated person can lean against. And we're going to call that invention a chair. Well, that is not just a stool, it's a chair. It's novel in light of the prior patent, the stool. But let's think about it. The chair person actually cannot practice the chair patent, because if he were to sell a chair, that chair would infringe the stool patent, because the chair has both of the elements of the stool claim. It has the horizontal platform, it's something to sit on. For all practical purposes, it's a stool, but we've added the back to it. But at the same time, the owner of the stool patent can't make and sell chairs, because in doing so, he would infringe the chair patent. So what should happen here? The stool patent would like to make chairs, and the chair patent would like to make something. So it would make sense for them to get together, cross-license and agree who can sell what to whom, and both patents stand as valid and issued patents. Non-US patents, which I made some reference to earlier, are a little different. You have, as I said before, a 1-year grace period after the filing of the US patent to file in other countries. And on top of that, you can file what's called a patent application under the Patent Cooperation Treaty. If you do that within 1 year, that gives you an even more extended period of time to perfect your patent in other countries. The Patent Cooperation Treaty covers 152 countries, whereas the Paris Convention covers 173. The PCT, or Patent Cooperation Treaty application, buys time in that you have 30 months from the filing of the US patent application to file the PCT application in different countries and the countries you want. We try to delay the cost of filing in countries other than the US until we have a licensee who can make a business decision as to where else in the world it makes sense to create and build a patent portfolio. The patent cooperation treaty application receives preliminary examination and a report from the receiving office for that gives you some clue as to whether a patent application in other countries will be allowed. The national filings, which have to take place within 30 months of the original filing, are country by country and very expensive. After they're filed and in these countries, in addition to the filing cost and preparation costs, there are annuities that have to be paid every year to keep those patents alive.